Hi, I'm Katie Sundstrom. I'm an attorney with the law firm of Lawrence & Thompson PC in Houston, Texas. And today I'm going to talk a little bit about trademarks, the importance of getting a trademark registration, and other ways that you can protect your trademark rights. So before we get into that, what is a trademark? Well, a trademark, it can be a distinctive word, phrase, sign, or indicator used by a legal entity to set its products or services apart from others in the mind of the consumer. How do you obtain trademark rights? Well, you're the first user of this mark in conjunction with the goods and services that you sell. And in order to obtain actionable trademark rights, you must be the consistent user in commerce in conjunction with the goods and services. Now, in order to get federal trademark rights, you not only have to use it inside your state, locally, you have to use it interstate. So you have to use it in a way that gives you rights across state lines. So what does just use of your trademark give you? Well, first it gives you the right to exclude others from using confusingly similar marks. Sometimes it gives you geographic rights. So if you haven't used it interstate, it'll give you rights within your geographic area to use your mark. And in some cases, it will give you the right to use it within your market or just within the type of goods that you sell or the channels of trade that you sell those goods in. If I get all this with common law rights, why would I want to get a federal registration? With a federal registration, it opens up a whole new set of rights that you get through the Lanham Act, the Federal Trademark Act. And it also increases your ability to keep others from encroaching on the goodwill that you've invested so much in developing your brand and your product and your relationship with your customers. When you obtain the registration, you're automatically considered the nationwide priority user of that mark in conjunction with your category of goods and services. It allows you to prevent others from using and registering similar marks. So if you've registered the mark in your category of goods and services, then others are unable to register a similar mark and get the rights that come along with registration. And after 5 years of consistent use of a registered trademark, it becomes incontestable. So if I get all this with common law trademark rights, why do I need a federal registration? Well, it gives you enhanced rights under the federal trademark statute. So in doing all of this, what you're trying to do is prevent others from encroaching on the goodwill that you've developed in your mark, in your name, and in your relationships with your customers. So a federal registration, first of all, it gives you the status of the nationwide priority user of your mark. And that gives you the ability to prevent others from getting federal registrations in your area. And after 5 years of consistent use, your mark becomes incontestable. And as with other types of registrations, it also opens up statutory remedies, which include damages for willfulness, damages that include attorney's fees, and the opportunity to get injunctions. A useful and sort of non-legal reason to have a trademark is so that you give users and your competitors constructive notice that you intend to use your trademark, as identifying your goods and services. So when you get a registration, you have the ability to use the circle R next to your mark, next to your logo or name. And that puts it in the mind of your competitor that, okay, this is a proprietary word, this is a proprietary phrase, and sort of gives them the warning sign that they need to use it in a non-infringing manner if they choose to do so. And again, it's a deterrent to infringers. It's like a beware of dog sign, putting them on notice. Another reason to get a registration is that it takes something that's amorphous and puts it in a package that can be an asset for your company. Something that would otherwise be intangible, you can, like the goodwill that's developed in your brand, it actually makes it an asset that you can monetize and that you can put a dollar sign on. It can increase your ability to quantify your goodwill. It can, and you can do that. You could put it on your balance sheet. You could put it in your net worth by using comparables. There's experts that can go out and look at comparable licensing in your industry, and it sort of solidifies that as an asset for your company. And it also allows you to transfer the goodwill that you've developed to other companies by licensing your mark so that asset can be transferred, you can monetize that asset. The last reason that I think is a great reason is that it gives you the ability to take control over domain names that may be confusingly similar with your trademark. And without the registration, you have almost no recourse against somebody who's using a confusingly similar domain name to your trademark. Without the registration, you don't have those tools. That you can go through the UDRP. There's an arbitration process that you can go through. It's very bureaucratic and quick. And with a registration, you have almost automatic rights when somebody has purposely registered a confusingly similar domain name. And further, along with that goes say that you're doing some internet marketing and people are using confusingly similar keywords or Google AdWords so that when your brand is searched, your competitor's page comes up. Well, because you have a registration, it's much easier to go to a search engine like Google or Bing or one of the other ones and say, look, I have this registration and you need to take the AdWords out. And without a registration, you wouldn't have that opportunity. So what's the registration process? There's three main areas to look at. The first is to do an availability search, whether you do that through a search company like CompuMark or through an attorney, and to get an opinion letter from a qualified trademark attorney. You would do this so that you would prevent infringement on others' marks before you start using your trademark, and it's also a future defense against willfulness. So if you've been using your mark for a couple of years, you got a registration, you did this search up front, and somebody comes along and says, you're infringing my mark, and you always knew you were infringing my mark, you can have a defense against that by saying, well, I searched for your mark, and here's proof that I did it, here's an opinion I got from my attorney, and so it sort of rebuts their argument. It's also a deterrent against litigation in the same way. So if you were threatened with infringement litigation, you could rely on your search report and on your attorney's opinion letter to stave off future litigation. The second step would be to apply to the United States Patent and Trademark Office for your registration. And what that process looks like is you either can do it on your own or you can hire a trademark attorney, and the trademark attorney will go through the application with you, submit a specimen of use, and file that with the Patent and Trademark Office. The examiner, within 3 months, hopefully within 3 months, will go through your application and either accept it or send back an office action and have different communications with your trademark attorney until it either ultimately is rejected or hopefully accepted. And when the registration issues, you get your registration number, you get the ability to put the Circle R on, and then you get all of the statutory benefits of having a trademark registration. But your burden does not stop there after getting your registration. You should have a program of management for your asset. So you need to consistently police that mark, make sure if people you know of are infringing that mark that you go and somehow take care of that. That's a program that you can go through with your attorneys and sort of set up a process for for policing that mark. You need to make sure that when you're contracting with others and you're using your trademark in your relationships with others, like between companies, if you're doing events and they're going to be using your logo and things like that, you need to make sure that your contracts address how they're using your mark. And also through trademark notices, so that if you're using your trademark on your website, make sure that you notify others that this is your trademark and that you consider this your property. And there are a lot of post-registration filings that you need to be aware of. And if you do hire an attorney, they will take care of that. But within a certain number of years, you need to file affidavits that you're still using the mark and examples of use. And then you also need to file, they're sort of like maintenance fees, so that you maintain your trademark over time. So I hope you learned a lot from me today. It's in a nutshell, sort of a broad overview of the trademark process and why it is beneficial to you. I'm Katie Sundstrom with Lawrence & Thompson, BC.